under the Crown to comply with Chapter 3 of the Constitution.
All right.
And he didn't, so he cannot sit in the court. It's a fraud.
All right. So, as I understand what you say, in grounds 1, 2, 3, 4, 7 and 8, you say the court was not lawfully constituted. That's the substance of it.
That's correct. And if you look at Kirk Merson Industrial Relations Commission at 96, it says it is beyond the legislative authority of the Parliament to so alter the Supreme Court of the state that no longer complies with Chapter 3 of the Constitution. When the state repealed Schedule E to the state constitution, which is the oath of allegiance to the Crown, using the Oath Affidavits and Statutory Declarations Act in 2005, they made the Constitution of the State of Western Australia repugnant to the Federal Constitution and all state laws. Now, the Supreme Court no longer meets the requirements of Chapter 3.
All right, Mr. Glew, in relation to paragraph 5, do you intend to allege there that the Chief Justice refused to allow you to sit during the course of the trial, refused to permit you to represent the company during the course of the trial, or was this a decision that was made at an earlier point in the proceedings?
It was made at an early point in the proceedings. I believe on the 26th of July 2009. It was made again on the 7th of September, the first day of the trial. That is an act of slavery contrary to 268 of the Federal Crimes Act 10, 11 and 12. I was forced to sit with my company in this court without representation and without being able to say that is slavery.
Did this issue not arise in previous proceedings in which you were involved in 2007, involving the Department of Planning and Infrastructure?
No, it did not. Not in relation to slavery, and not in relation to the inability of the court to deny anybody the right to represent themselves, both in common law and in statutory law.
But did the court not hold in that case that you could not represent Glew Technologies in proceedings in this court?
It wouldn't matter if it did, sir, because you're using Supreme Court rules which do not comply with Chapter 3 of the Constitution. The court does not have legislative authority. Chapter 3, Section 71 states that the legislature shall not give legislative authority to the judiciary. They have none.
All right. Was there anything further you wanted to say in respect of the grounds of appeal in connection with the matter that's before the court this morning?
Because of the status of the Supreme Court and the grounds of the appeal, the matter is interstate. It must go before 3 judges in the High Court in accordance with the Federal Judiciary Act.
Mr. Glew, just one other couple of other things. In ground 6, do you say that the fact that, as you say, that the Chief Justice on your case ignored parts of your evidence, that in itself is evidence of bias and fraud by the Chief Justice? Is that the point?
Well, I can make a point by putting to you that an actual point in the case. Patents are issued on their independent value. For instance, they have to be new and novel. There were 3 patents. The third patent had 2 inventive steps that were split into 2. Evidence that in international law, which overrides all other law in relation to patents, it is done by agreements. A patent has to be new and novel. The 3 patents were adequately explained in the court by me in relation to the physics of the system as 3 completely individual patents. They all vaporize fuel, but using 3 different independent methods. The third patent had a method of vaporizing using airborne thermal cracking, which I don't expect you to understand. But it was split in 2 because part of the system can control the airflow into the motor by a spring calculated against the vacuum of the motor. Now, they are independent and completely separate patents. Mr. Martin said they are all enhancements.
But is your case the point in ground 6 that the Chief
evidence, but in an evidence under statement under cross-examination, I admitted knowing that a particular person was in the Midland lockup charged with an indictable offence when I was not aware of that whatsoever. It didn't come out in evidence, but he stated it didn't. Now that is an absolute lie.
Yes, but I'm just saying, is your ground 6 that the Chief Justice deliberately ignored or misstated evidence in order to commit fraud on you? Is that the essence of your complaint?
That's plus an email sent from one of the people in the case, being Joe Jasper, to my home on Christmas Day, outlining exactly the same lie.
No, I'm just thinking.
Well, it is part of that, sir.
But your ground 6, I don't think, deals with that email. It deals with the Chief Justice ignoring parts of your evidence and acting in fraud and bias.
This email proves conspiracy between the complainant and the Chief Justice. And he used to work for this person prior to becoming a judge.
So is ground 6 really part of the wider issue of conspiracy?
Oh, it's a big, wide issue of conspiracy, yes, sir, with all the evidence here for a prima facie case.
So I just want to make sure I understand this. Ground 6 is addressing a deliberate ignoring of evidence by reason of bias and fraud. That's the first point, is it?
That's correct.
And the second point is it's part of this wider ground of conspiracy that you have in ground 7.
That's correct.
It's not a case, I just clarify this for my own purposes, you're not simply saying the Chief Justice overlooked evidence or failed to take account of evidence. You are saying this was simply part of the conspiracy. Is that correct?
That's correct, sir. I spent 17 years in the Western Australian Police Force, and I know what constitutes a prima facie case for a criminal offence, and this well and truly constitutes that.
All right, thank you. All right, thank you, Mr. Glew.